Why do lawyers call bad evidence fruit of the poisonous tree? And why did the citizen accused get the case thrown out after they found cocaine, and a gun in his car? All this stems from a case back in 1999. It's called Arizona v. Gant. And what happened was the cops were staking out this drug house, and they had suspicions that they were selling drugs there. A couple officers, and based on the case, it looks like they were non-uniform, so they're most likely detectives. They show up to the house, and they're just going to do what's called a knock and talk. Like, hey, we just want to talk. And at that point, what they're doing is some investigation. They're looking what's called plain view. Plain view doctrine says if they see anything that allows them to develop probable cause, they might enter, or they might go get a search warrant. But they knock on the door, and this citizen named Gant, he answers it, and he's talking to him. Now, at this point, Gant, he identifies himself, and I'm going to assume, and I can't tell from the case, but he identifies himself. That means he probably produced identification. You might be asking yourself, was he required to produce identification at this point when the officers come to the door? Now, Gant wasn't the homeowner. What happened was then the officers left, and at some point, Gant left also. But when the officers left, they ran his name and his ID, and they found out that he had a suspended license and he had a warrant for a case for driving on a suspended license. So that's called a violation of probation. Now, usually if you have a VOP for a driving on a suspended license, it's not something they go out and arrest you for. It's something that they usually will give you another ticket that says, hey, show up in court. And again, this is 2023 I'm talking about. 1999 in Arizona, it was a whole nother ball game on how they approach cases. Anyway, so now the cops know that Gant doesn't have a valid license. Gant leaves, cops leave. Cops show up, and now there's a couple uniformed. In total, there's going to be 5 officers on scene. A couple officers show up back to this house that they suspect to be a drug house. And when they suspect it to be a drug house, a couple people, a man and a woman, they end up getting arrested for some other stuff. Then here comes Gant. Gant rolls up, he drives up, and as he's driving past, one of the officers who initially came to the house saw him and said, hey, I know he doesn't have a driver's license. He gets out, shuts the door. Now, it doesn't say whether it's locked or not, but he shuts the door. As he shuts the door, one of the officer motions over to him. It says that they had contact. Now, this is where another legal issue is. Were they words of command, demand, or words of request? If the officer's using words like, hey, can I talk to you? And you walk over, that's called a consensual encounter. Kind of hard to challenge the detention at that point. If the officer says, hey, I want to talk to you, that's kind of in the gray area. Hey, come here. That's in the gray area. What's his tone of voice? Hey, I want to talk to you. Those are words of command. So he ends up talking to Gant, and as he talks to Gant, he ends up hooking and booking him. So he handcuffs him, gives him a free set of silver bracelets. He's handcuffed. They put him in the back of the car, police car. Now, before this case, what officers did is if they arrested you, they would then search your vehicle. However, the issue was he was arrested and secured. That means he's locked up in the back of the police car. Then the officers went to search the car. Well, what did they find? In the back seat, they found his jacket, and they found some cocaine in the jacket, and they found a gun in the car. Now, this was the problem for the court. They said, yeah, I don't know if that's a great search. And what the court ultimately was saying is that if you're going to do a search because of an arrest, and the fancy word lawyers use is incident to arrest. If you're going to do a search incident to arrest, then the search has to be related to the crime for which you're arrested. Well, in this case, Gant was arrested for driving on a suspended license. So what could they really look for? So what happened is the trial court denied his motion to suppress, and a motion to suppress is saying, hey, Judge, I don't think the officers followed the law and they violated my Fourth Amendment right when they did this, this, and this. If the trial judge agrees with you, then they kick out the evidence. And that's called fruit of the poisonous tree, because what they're saying is the tree, the search was bad, and everything that grew out of that search is bad, i.e. fruit of the poisonous tree. Well, the trial court said no. Then the case went up to the Arizona Supreme Court, and the Arizona Supreme Court said, hey, trial court, you guys messed up. We're reversing it. Now, at that point, they overturned his conviction. But then the prosecutors, and there was a lot of other people who petitioned the court, but the prosecutors petitioned, and it went up to the U.S. Supreme Court. And the U.S. Supreme Court decided, saying, you know what? Yes, everything that the lower Arizona court said was true. This was a bad search, i.e. fruit of the poisonous tree. Hope you've enjoyed this video. Thanks for watching. Have a great day. Fat out.